Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Okay, so this is case number 2402470, Imperial Senior Suites versus Elizabeth Bray.
Good afternoon, Your Honor. Harold Goodstein, P24300 on behalf of plaintiff.
Morning, Elizabeth Bray.
All right, and today it's a motion. We're scheduled for a motion to set aside a judgment. And let me look and see what we did here.
For the record, Your Honor, I have not received the motion. It wasn't served on me, and I don't know if any money's been escrowed or not.
Well, let's see. I don't know. Let me check. It's gonna be an on-base. Yes. Yeah, they scanned it in. It says motion to set aside consent judgment. But I don't understand why we signed the consent judgment in the first place, because you're saying in your set aside that you would set a 7-day notice for non-payment dated January 2nd, first class mail on January 18th. I have proof. Court was filed January 17th. I brought this to court January 11th and tried to explain to the attorney for plaintiff, he disregarded me. So, ma'am, but apparently, and I'm gonna let you explain what all that means because I'm not sure what it means, but apparently when we came here, you entered into a consent judgment, and I'm gonna look for a copy of that judgment here. And I know I asked all the questions on the record because I have to.
I have a copy if you need it, Your Honor. That was entered with the court.
So I guess I'm not understanding. Usually when you set aside a judgment, it's something about your rights that you don't understand what you just did.
No, it wasn't that, ma'am.
That's usually the basis to set it aside is because you didn't understand the rights that you gave up.
When I came here and I spoke to him in the conference room, I attempted to show him what I had.
Well, what is it that you had that related to the rent?
I'm not saying that I don't owe the rent. I'm saying that the 7-day notice was not given to me in a timely manner to get me into court. Okay, I didn't get the 7-day notice until 11 days after it was, well, actually 17 days after it was dated. And in the process, the court date was in before I even got the paperwork to let me know about the 7-day notice.
Okay, so what would you like me to do now?
Basically,
because the remedy, let's just say they never gave you a 7-day notice, then the remedy would be for me to dismiss the case. If you never got a 7-day notice, then they would just refile the case. Then you'd still owe the same rent, plus probably new rent if there's more months that go by.
I don't have a problem with that.
Yeah, what?
I owe the rent. Okay, I am disputing with Section 8, but I do owe the rent. Okay. I just wanted more time or to have this done properly.
Well, I don't know that it was done improperly. You said
Well,
you got it late.
Legal aid told me that because I get Section 8, that I have supposed to be served a 30-day notice.
I don't know.
Under the CARES Act?
I never heard that there's a notice exception if you get.
It's called the CARES Act.
Okay, I don't know about that, getting a 30-day notice because you get legal aid. Do you know about?
No, not getting legal aid.
I've heard
I get Section 8 housing.
I know about the CARES Act generally, but I'm not familiar with that provision. Are you familiar, Mr. Goodstein?
Your Honor, what she's talking about is there was a provision under the CARES Act if they're getting federal subsidizing that when they issue a 7-day notice, that they're given 30 before they can take a judgment.
Okay,
And she's had way over 30 days notice, so this is not even relevant here. And I explained to her out in the hall, if she just needed a few more days, she could have called me and asked me for it. Or we could have amended the judgment and added Mays on, which is due
And
now.
you didn't give me that.
Can I finish speaking? I
I'm
listened to
sorry.
you.
I'm sorry.
okay, stop, Mr. Gussie, you don't yell at her.
Well, she started up with me out in the hall, so. I explained to her that I could have amended the judgment. I could have given her the additional time and added Mays on. Now there's another month's rent due, and I'm not sure if Your Honor answered me if there's been a month's rent escrow with the court.
Well, let me go on I gotta go on JIS to see that. Let me see.
She may know if she escrowed any money.
What do you mean by escrow?
Put any money with the court for rent.
I
On a
can,
consent set aside, I don't think they have to. So she might not have. Let me see though.
I can make payment right now. If that's, I don't know if the escrow means.
Escrow means that in order to usually on certain kinds of motions, especially to set aside default judgments, you would have to put money like 1 month's rent into escrow just to cover the plaintiff because they have a possession judgment, just to cover the delay.
So escrow, does that mean my bank account?
No,
or
my court.
Oh, I can do that.
Yeah, no, but the question is, had you done it? I
Oh,
don't think so. I don't think we require it on a consent judgment set aside. But let me see. If there's anything in here, I don't think it is.
It hasn't been, Your Honor. My two suggestions would be, one, to deny her motion, and we'd ask for immediate writ to have her evicted. Number two, that we amend the complaint to add on May's rent and give her 10 more days. With the understanding that that would be the last motion.
Yeah, there's no escrow on this. Yeah, so your argument is you don't think that they gave you a notice, 7-day notice?
They did, but it wasn't within 7 days, so I didn't know anything about it until after it was already filed in the court.
Okay, well, how did you get it?
I got it through the first class mail. And it arrived on the 18th, dated January 2nd.
The 18th of what?
January. And then we got into court for.
Okay, so they mailed it on the 2nd, it says.
No, that was when it was dated. It wasn't mailed till the 16th,
Okay.
according to the postage stamp on
Okay.
the federal mail.
And when was the case filed?
The 17th of January.
I'd also point out, Your Honor, that none of this was brought up at the last hearing.
You didn't give me a chance.
Ma'am,
We
hold on, let me just say something.
told me I couldn't see.
First of all, I don't know why you listen to what he tells you you can say when I'm sitting right here and you can talk to me all day long. Tell me whatever you wanted me to know. Why would you let somebody tell you you can't talk to me?
Because that's what he told me.
Who told you you can't talk to me?
He told me just go and sign this paper, da da da. I don't care.
You always
what you
do
got.
what people just tell you to do?
Yeah,
When you came into this court, I'm gonna tell you what I know I did. I asked you, did you wish to sign this consent judgment? And did you understand that you were waiving certain rights that were on the video that you probably watched? And if you didn't understand the video, I usually go over it again if somebody needs to. You could have told me then, I don't want to sign this. Why didn't you tell me that? If for some reason you didn't want to sign it, you didn't have to. We could have had a trial on what's due and owing. You could have then said, I think there's something wrong with this because I never got the notice.
I thought that's what I had to do by talking to him. and
Ma'am,
then-
he's not your lawyer, number one.
No.
So why would you think he had your best interests?
Because I don't know the law.
Okay, but you do know he doesn't work for you. You know that much, right?
Yes.
So if you had a question about the law, I don't work for you and I don't work for him. I'm a neutral person here. So why wouldn't you ask me the question that you had?
I didn't know I had that right.
You didn't know what?
I didn't know I had that right at that time. I thought it was just the final process. That's why when I got home, I called legal aid and they told me to come back and.
So you called them after the hearing, not before?
Right. I thought with what I had, it would have been dismissed instead of going through.
With what you
So
had?
I didn't, with the 7-day notice, so I didn't.
But
know-
no one raised the issue. Who could dismiss the case if we don't even know this is an issue? You never raised the issue until after the case is over. This case is basically over now, but you're coming back raising the issue. So why didn't you raise it when you had a chance to tell me? I mean, we're still here, I guess, but.
Your Honor, she admitted and still admits that the amount of rent is still due. So I'm not sure what the issue is at this
I
point.
guess the issue is that the rules tell us we have to hold, strictly construe these landlord tenant dates and times and things of that nature. And if she never got a notice of quit, even if she came, it's still defective. She's saying she didn't get it in time. So therefore, if the process is defective, I might still have to dismiss it. But the problem is if I dismiss it, he'll refile it and he'll get another judgment adding on to just everything that he offered to add on to today.
I understand.
So, but I mean, I can do that if you want to go through all of that again. Potentially.
Yes, I do.
Okay.
I would object to that, Your Honor. I'd ask that you review when we were in court last time, when she admitted that she owes it and when you explained her rights to her and that you asked if she had any other issues. She said no. And if you would review that court hearing, you would see that she was given more than ample opportunity. Because you always explain it to almost everyone.
Ad nauseum, I know I do.
I know you do, plus you showed the video on top of that. And this is nothing but a delay tactic to try to get more time to pay the rent, which I've already offered to amend the complaint and give her time.
Well, why wouldn't you he just offered that today? Do you want to do that?
He told me.
How
he
much
didn't wanna
more
hear
time?
anything that I had to say.
I never said that.
Okay, well,
I said it right at the beginning of this hearing and I'm saying it again.
let's just say
Is that
that.
what you said?
Okay, whatever he said in the hallway, he's saying something different now.
Correct.
Okay, so let me ask you this. What's your point? You want more time to do what?
I have a social security settlement coming in any day now. That's what I'm using to pay the rent.
Okay, and so how
So,
long?
I thought it was supposed to be here by the 3rd. It's not. It didn't come in.
How much
today.
more time do you want?
10 days, 15 days.
Okay, so let me ask you this. Rather than go through this whole process again, which I can look at the dates, I can check and see. Would you want to waive that argument and just amend the judgment to add on what's now due for May? And we'll just give you the extra time.
What if it doesn't come in?
Well, ma'am, I mean,
I
come
know.
on, at some point.
I know. Let's do that. That's fine.
At some point, it might not come. I don't
I
know.
know it's gonna come.
But, let's just say, if Mr. Goodstein were to get this case dismissed now, go back to the office, refile the case, Monday, because he's probably not gonna do it today. But if he were to do it Monday, he's gonna get a fairly quick hearing, and it'll probably be, probably before the, I don't know, this is the 3rd, maybe before the end of this month anyway. We'd be right back here on the same issue.
Right.
So if we gave you towards the end of the month, would that be sufficient
Yes,
for
it
you?
would.
I think that could work.
Thank you, Ron.
Mr. Goodstein, that could work.
I can't give her till the end of the month. She's already had
Well, I can't,
from April 11th.
or either I can look at this other
And the
issue.
new amount,
If
Your
you
Honor.
guys don't want to agree to it, then let me look at the issue of the service of the 7-day notice.
Okay, Your Honor, the rent now is $3,127 plus $160.04 for a total of $32,87.04. If we amend the complaint to that, what date are you looking at? The 10 days would be May 13th.
Right, and I'm gonna give her more,
How much more?
probably till like May 31st.
Thank you, Ron.
It's in a month. That makes up for any possible defect that there could have been,
Could we
if there
put-
was one.
Can you put in the order that can be no motions or appeals from that she's done and she can't come back if she's
Yes.
never checked by then?
Yes,
So we don't get stuck here again?
yes.
So
You
can
get
I
that,
just
right?
cross off the numbers on this judgment, make it amended, and have her initial it, and should I upload it?
Well, I don't know what you, I can't see what you're looking at, but you could change
I have
it.
a copy of the old judgment here that before it was entered.
Right. Do we just have a clean judgment form? Do
This
we have
one's
a,
pretty clean. I can show it to you.
yeah, because otherwise we'll just mark it amended and get you a new one, and I'll grant the,
What, you want me to, should I approach with this one? You want to look at it before we fill out another one?
yeah, well, I'll look at it. And this is not a default judgment, so I got a wrong order, so we're gonna do a
The
motion.
other
to
one was
set-
a consent. This is the old judgment, and I just changed the numbers and the date on it and called it amended.
And then, but we gotta change the signature and everything. So we gotta do all of this.
Unless you want to do it by hearing. And we don't even need a signature.
Well, I can sign it, and the dates are wrong for this. So let's see, you would have to put 5/3. You wanna use this? And we'll just say 5/3. Change everybody's date to 5/3. And then we'll change this appeal date will be,
13.
yep, 13th. And then we'll do the 31st up here as the move out date. And then we'll change everything to, it's 30, is it 3287?
Yes,
You forgot the 04.
that was on the call second.
328704. Money judgment, and then you can scan it in and I'll sign this.
Should we put on number 10, no motions?
Yeah, we'll put in, no further motions to stay or set aside judgment will be, entertained.
Should I put this by hearing or by consent?
Everybody can see.
Should I have her re-sign it?
No, because I just changed the date, so we just
Oh,
need the
okay, so we're
signatures.
all set, I'll just upload
And
it.
then you just need to upload it so I can sign it.
Okay,
And then I'm gonna do an order here, uploading to grant your motion to set aside the consent judgment
we're just gonna put amended judgment, consent
and,
judgment.
and indicate that the parties will enter an amended judgment.
Will I receive a copy of that?
Once it gets, it has to be uploaded into the system. I will then electronically sign it, and then when it goes back out, you'll get a copy of it. This other motion, this other order right now, you'll get it now. And what was the date on that consent? Let me see. Original, I think it was
Okay.
4/16. And let me just tell you, Ms. Spring, next time you ever, if you ever have to go back to a court again, whatever your concerns are, you bring it into the judge and ask the judge what your question is. Don't just say, I have to sign this because somebody told you, because you
Okay.
don't.
I didn't know that. Oh. I didn't know I had, thank you.
Even though I told you on the record, do you know you have certain rights? You understand you're waiving those rights. You said yes.
I know.
And if you probably did it because you didn't disagree with the amount.
No.
But what you didn't do was raise the other issue that you wanted to raise. You can always do that. His job is to adequately and zealously represent his client and try to work out each and every one of those cases. So he's gonna tell you what he thinks is in his client's best interest, and if you tell him I don't have a problem with the rent amount, then he's gonna ask you to enter into a judgment. I mean, that's normal, but you don't have to say, you could say, well, I really don't disagree, but I want a trial. Then you come tell me that, then I decide if there's a triable issue or not. And if there's some other issue that you have to raise, you come and tell the court. That's in any court proceeding. That's not your lawyer. You don't have a lawyer. If you want a lawyer, you should have done what you did after the hearing, was call ahead of time to Lakeshore Legal Aid, and they could have given you some assistance, even if they choose not to represent you in the case.
Right.
They can give you some background information and tell you a little bit about the law. That's what they do. So next time, just ask, speak up, okay? Now here's the copy of the order.
Should I approach for a copy, Rory?
Yeah, I think we can get the court officer to stamp this, and then we'll upload this one ourselves to,
Wait for Jessica.
well, yeah, okay, because he'll stamp it. Mhm.
Thank you, Your Honor.
Okay.